Hello everyone. In today's video, we will look at such a concept as structuring transactions. Structuring of transaction is first of all the construction of an individual model of financing an investment project aimed to satisfying the interests of the borrower, the initiator of the project, and the lender, the party taking on a significant part of the risks of the project, as well as the interests of the other project participants. Structuring of transaction involves the definition of a specific product to be provided to the client, the parameters of this product, as well as a combination of accompanying risk management operations. At the same time, it is a process that takes into account the specifics of the project, the rights and the capabilities of its participants in risk management and cooperation. The crisis has shown that the usual structure of a loan transaction involving one borrower company without involving shareholders and founders as guarantors and without analyzing the interaction of the borrower with the group companies leads to serious problem with the repayment of the loan in case of problems with the borrower. Let's consider what the structure of transaction is and what factor it depends on. The structure of a credit transaction is a set of credit conditions participants in the transaction, legal entities and individuals, as well as a specific legal formalization of the relationship of participants in the transaction with a credit institution. The factors on which the structure of the credit transaction depends are the borrower credit history, the approaches used to analyze the borrower's creditworthiness and collateral assessments, the degree of risk that the credit institution is willing to take, the experience of the credit institution employees, the client ability to desire to accept the proposed loan terms, the purpose for which of the loan product is requested, the situation on the lending market in this region. I must say right away that there is no unbiasedly correct structure of credit transaction. The final structure of the loan transaction depends on many factors, which are quite difficult to influence and in some cases impossible. Let's look at the certain approaches to help bring the structure of a credit transaction closer to the optimal one from the point of view of credit risk for the lender. These approaches can be formulated in the form of rules for creating an optimal structure of a credit transaction. Rule 1. Choosing a borrower. In the group of companies request credit resources, it is necessary to insist that a company with the following characteristic act as a borrower. It is the balance sheet holder of equipment, real estate, or other core assets to the group. Closes the production functions of the group. The main cash flows of the group pass through it. In other words, it is necessary to understand what is the determining factor in this business and find a company in the structure of the group that concentrates this determining factor. Rule 2. Guarantee of business owners. The guarantee of business owners is important rather as a disciplining factor as well as a proof that the owners are confident in their business. Rule 3. Guarantee of the pledgors. It is necessary to strive to ensure that the mortgages on the loan always give their guarantee. By issuing a guarantee of the mortgage, the credit institution solves two important tasks. The loan security is strengthened. In case of foreclosure on the loan, the mortgagor will be responsible for all his property and not just the subject of the pledge. Rule 4. Guarantee of the main companies of the group. When working with a group of companies, it is necessary to issue a guarantee of the main companies of the group. Rule 5. Do not issue loans without collateral. If we are talking about an average borrower, loans to him must be secured by collateral and/or surety, the presence of which not only serves a disciplining factor but allows, in case of deterioration of the situation, to repay at least part of the loan by selling collateral and receiving funds from guarantors. Rule 6. The loan terms should be comparable to the financial cycle of the company or related to the return of investments. In investment lending, the loan term must be linked to the payback period of investment and calculated on the basis of cash flow. Rule 7. The type of loan product must be selected in accordance with the purpose of lending and the specifies of the borrower. Rule 8. It is necessary to control the intended use of the loan and the source of its repayment. Compliance with all these rules allows you to reduce credit risk. Let's look at such components of a structured credit transaction as covenants, which also reduce the risks associated with the counterparty and its creditworthiness. Covenants are the terms of a loan agreement that establish the borrower's obligation to perform or refrain from performing certain actions during the loan term. For example, when concluding a loan agreement, the borrower undertakes to take loan from other banks only with the permission of the lender bank. Thus, the lender receives guarantees of the borrower's financial stability. There are different types of binding covenants: positive and negative. The obligation to commit in action or refuse to commit it. Financial or non-financial. The latter include informational, the obligation to provide access to information or make a report. Inseparable and personal. Apply to any property owner or to specified person. Important elements in the structure of any loan agreement designed to reduce the risk on the lender are: prerequisites. In order for the lender to have an obligation to provide a loan, the borrower must fulfill the prerequisites defined in the contract. assurances and guarantees are provided directly when issuing a loan and include two basic categories. The first confirms that reliability of legal facts concerning the legal status of the borrower, the power of its representatives, and the legal documents submitted. The second covers the commercial basis of the borrower's activities, including its current financial situation. Covenants. Their function is to provide the lender with certain control over the borrower in the future, after the loan is issued, and to restrict the borrower in carrying out operations that, in the lender's opinion, may have a negative impact on the borrower's credit rating and his ability to repay the loan. Therefore, when formulating covenants and predicted negative factors are taken into account. Default events. Violation of covenants is usually recognized as a default event. Upon its occurrence, the lender has the right to demand early repayment of the entire loan amount, as well as to terminate the provision of the next credit tranches in the case of the credit line. In credit agreements, the following covenants are often found: requirements to provide information about the financial situation of the borrower, transactions on his accounts. Financial covenants, which represent the minimum or maximum limits for indicators calculated based on the financial statements of the borrower or a group of companies. Restrictions on the disposal of the borrower's assets, including their transfer as collateral. Restrictions on the provision of collateral guarantees, sureties, in the favor of third parties. The requirement not to enter into obligations, the order of which is older than loan debt. What are the consequences of breaking covenants? Violation of covenants is a technical default, as opposed to non-fulfillment of the main obligation to repay the debt and/or accrued interest on the loan agreement. They may be transitional states in the borrower's financial situation. Therefore, credit agreements include not only the right of the lender to demand early repayment of the loan, but also other consequences. Change in the interest rate, the requirements to make additional collateral, changing the schedule or of loan repayment. That's all for me. See you in next video.